Hi, my name's Jessica Motto, and I'm responding to Week 2, Discussion 2 for Class HCA 322. Based on the information provided from the defendant and the plaintiff, I would have to side with the plaintiff, Jennifer. Since there are no facts stating that Jennifer's information was deemed de-identified, it is covered under HIPAA, which is a privacy rule that restricts disclosures and limits use of personal health information without a patient's permission. However, there are certain times when personal health information must be released without authorization from the patient, which would be when an individual requests a copy or accounting of their personal health information, or when the Department of Health and Human Services needs access to personal health information to facilitate an ongoing compliance investigation. There's also times when entities may disclose personal health information without individual authorization to other entities. Examples of these times would be for treatment, payment, and healthcare operation purposes, the standard part of most healthcare transactions. Also, law enforcement purposes, judicial and administrative proceedings such as subpoenas, commercial marketing, parents of minors, health research, and finally, public health reasons. The reason for my decision really falls with how the subpoena was executed. Since the patient was not made aware of the subpoena until after her personal health information was already released, that appears to be the main violation to me. Although she may not have had to authorize the release, proper notification of the subpoena would need to be made. Since the defendant could not speak to proper notification procedures and there was not any communication to the plaintiff, I feel that Jennifer's rights were violated. Violations of personal health information has seen continued problems, and new progress continues to be made to try to ensure these types of things don't happen. In Connecticut, prior to the case of Byron versus Avery Center of Obstetrics and Gynecology, when a HIPAA violation occurred, the only option made available was to contact the Department of Health and Human Services and file a negligence claim. However, since this case, where the plaintiff won on an appeal, violators can be sued and entities that are found guilty are subject to higher fines. Since these are newer things that are being allowed, I feel that hospitals and all entities need to be super careful when dealing with people's information, and they need to be sure of every step of the procedure the entire way. I believe that AU Hospital may not have knowingly violated HIPAA. However, they did not follow the steps thoroughly and therefore still acted negligently with Jennifer's personal health information. When dealing with personal information, especially in the medical field, the proper procedure needs to be double checked, and every step counts. I think the execution of the subpoena is what really caused the issue in this case. And had that been executed appropriately, I think I would be siding with the defendant. Thank you so much for your time.